us on board. Today is June 16, 2011. This is a business meeting of the Citizens Redistricting Commission. I'm Jody Filkins-Weber, chair for this series of meetings. We do have a rotating chair policy, and to my right is Commissioner Maria Blanco, and she is my vice chair for this series of meetings, and she will be chair next week. At this time, I understand Councilman Weissman, would you like to say something today?
Good morning, and thank you, Madam Chair. My name is Andy Weissman. I'm proud to be a City Council member here in Culver City. Welcome to Culver City. We have a 5-member City Council, and we're not exactly set up for a group quite this large. So we appreciate your squeezing in and moving into the cheap seats, as I heard mentioned. On behalf of the City Council of the City of Culver City, I would like to take this opportunity to welcome the chair for the day, commissioners, and the public to today's meeting. I would also like to recognize and thank our fellow Culver City resident, Andre Parvenu, who was instrumental in helping to coordinate today's meeting, which is taking place in our council chambers. Today's commission meeting and the public input hearing this evening will provide an opportunity for the community to express their views on where the new boundaries should be drawn. The City Council believes strongly in involving as many community members as possible at public meetings, and we appreciate the Commission's outreach to the public in advance of today's meeting. We encourage the members of the public to enthusiastically participate. To the Commission, thank you for the countless hours that you have put into this process. We certainly appreciate your hard work and welcome you to Culver City. If you have an opportunity to take a break this afternoon, we encourage you to take advantage of our amenities in downtown Culver City, which you have worked so hard over the past 10 or 15 years to bring about. Thank you all. Best of luck to you, and thank you for your efforts.
Thank you, Mr. Weissman. Janice, may we have roll call this morning?
Commissioner Aguirre? Is he here? No. Commissioner Anchetta?
Here.
Commissioner Baraba?
Here.
Commissioner Blanco?
Here.
Commissioner Dye?
Here.
Commissioner DeGiulio? Commissioner Filkins-Weber?
Here.
Commissioner Forbes? Commissioner Galambos-Malloy? Commissioner Antai?
Here.
Commissioner Parvenu?
Here.
Commissioner Raya?
Here.
Commissioner Ward?
Here.
Commissioner Yao?
Here.
A quorum is present.
Thank you. At this time, I would like to open up the mic to any members of the public who wish to provide any public comment this morning. It is our custom and practice in our vision of listening to all members at each of our meetings. Do I see anyone who would like to make any public comments this morning on any item not on the agenda? I don't believe I see anyone. We'll obviously hear from plenty of people this evening. So at this time, the agenda is quite significant, and the purpose of the detailed agenda that we put together is to identify a series of issues that this commission has been working diligently to identify as well as to deal with at each of our business meetings. So although we may not get to every item on the agenda, the purpose was to make sure that not one issue falls through the cracks, and to also provide sufficient notice to the public regarding the issues that have been raised and the necessary decisions that need to be made by this commission. So although we do recognize it is quite extensive, it's likely that many items will be deferred, and so I've asked each of the leads to prioritize their discussions today so that we may work through each of these issues and make decisions for efficiency purposes so that we can put off those that can be put off to another meeting. At this time, I'd like to invite our voting rights attorney, George Brown of Gibson, Dunn & Crutcher, to provide a presentation to this commission regarding various issues.
Can you hear?
Well, first of all, good morning, and congratulations on getting that first great milestone. I want to talk today about work on where we are So what I thought I'd do is I will give you a quick summary of our views, and then I'll go back through and give you a little more depth. Let me start with Section 5. There are three things that I want to point out to you. First, as you know, there are a few instances in some of the counties where there are small populations where the proposed district has a slight deviation that's below the benchmark. Here's our view on that. While Section 5 does not provide any exceptions or exemptions for minor retrogressive changes, it does seem apparent from the case law that the DOJ could not meet the totality of the circumstances test for retrogression if the matter were litigated. Still, we think the better course is for these small changes to make an effort to meet the benchmark. And if it can't be met, to provide a brief narrative explanation about what was tried and why it can't be met. We don't think this is a huge task, but something that should be done. Second issue, with respect to Monterey County, and there was a congressional district, I believe the 27th, that had two options. Option one was drawn in a way that was not retrogressive relative to the benchmark. Option two is what got selected for the first draft maps, and it is slightly retrogressive for each of the groups. We think what needs to be done is either, if option two is desirable, try to make it meet the benchmark. Otherwise, in the absence of a compelling explanation for why the minority groups are better off with option two, the Commission should choose option one. With respect to Stockton, as you know, there's a substantial decline in the benchmark population for the Asian Pacific Islander group, in part perhaps because in making the district more consistent with good redistricting practices, the draft maps eliminates what's been called the Stockton finger. We think there are good reasons to adopt the district. However, the Asian populations in the two areas, we believe there's a Hmong population in the Stockton community. The Asian populations need to be evaluated to see whether, in fact, there was political cohesion or there was a relationship between those two communities in the prior districts. If, as has been suggested, that there is not a real connection between the two, and in fact there may be a preference to stay within the Stockton community, then we think that should be noted and explained. We also think that our Dr. Barreto, our new RPV analyst, can help us evaluate those issues a bit. That's Section 5. With respect to Section 2, there are 6 discrete areas that we believe are geographically compact, seem to have greater than 50% CVAP for a single minority group, and for which we've asked Dr. Barreto to help us evaluate whether there is racially polarized voting in the geographic area. And when that analysis is done, we will provide you a judgment about whether those are likely to be required under Section 2. Those areas are, I'll refer to the assembly districts and roughly by name of the area. There's one in Fresno. There's one in Pomona Valley. There's one that's called Rialto Fontana. There's a South San Diego. Then in LA County, there's East San Fernando Valley. And those 5 so far are majority Latino CVAP areas. Then there's San Gabriel Valley, where we believe there's a majority API, potentially. Now, in addition, under Section 2, there are a few areas where further evaluation of the CVAP estimate is needed. And in my notes, there are three that we should pay particular attention to. One is that San Gabriel Valley area I just mentioned. In the first draft maps, the data suggests that the CVAP is 49.95%. We need to ask our mappers to look more closely at that and see if they can come up with a better estimate of CVAP. Then in the Santa Ana area, there's an assembly district that has a 46.53% Latino CVAP. That should be looked at a little more closely. It's currently not being regarded as a Section 2 required district, but we want to evaluate that. And then South San Diego appears to be at exactly 50%, 50.0%. And so we'll want the mappers to look a little more closely at that. And while they do that, they also, in addition to evaluating CVAP, they should look to see whether there is an adjacent population that would push the number over the 50%. I suspect there's not, because they probably would have brought it to our attention already. My next issue that I want to discuss with you about Section 2 is, I think, the most important issue that the Commission needs to deal with, and that is Los Angeles County districts. In Los Angeles County, as you know, evaluating whether or not there are Section 2 claims is more complex than in some other areas because of the multiracial and multi-ethnic makeup of the county. Consequently, the Commission has undertaken to draw districts in LA, pending legal advice, based on the community of interest, neighborhood, city criteria, and to evaluate and while doing so, having sensitivity to not over-concentrating any particular population, and having sensitivity to minority representation. We think that's the appropriate thing to do. However, as we all know, there's been a lot of reaction from important voices in the community that says that the maps do not reflect their views of where communities are and which communities belong together. Consequently, I think there is some risk in the current set of maps that the Commission could be open to a number of legal claims if it did nothing further. And our strong suggestion is that the Commission undertake a reasonably vigorous effort to do further outreach, hear further information from members of the community, evaluate that information, and reconsider the districts and make a further determination that the Commission believes is fair in light of the further input. I think if the Commission does that, it will be in a very good position to defend its choices. I have some more specific recommendations on each of these that I'll go through in a minute. Let me point out, with respect to Senate districts, we believe that a lot of how those get drawn depends on the final look of the assembly districts. And so, rightly so, they didn't get as much attention in the first draft. We think that they need a little more attention, and I have some thoughts on how the Commission should be thinking about that. So with that as a general background, let me offer some more specifics, particularly on LA County, and then ask if there are questions. Here are some of the tasks I think the Commission should undertake with respect to LA County. First, conduct outreach to knowledgeable persons and groups and solicit further immediate input on LA cities, neighborhoods, and communities of interest, including which communities and neighborhoods belong together in a district and the supporting reasons. Two, I think we should conduct some outreach to groups with legal sophistication to solicit any legal analysis or arguments suggesting specific Section 2 districts that may be required, along with any supporting evidence that they're willing to provide. Our current view has been that we have not advised the Commission that there are any other Section 2 required districts other than the ones I've mentioned previously. I think we should ask our mappers to provide council with narrative explanations for each district in LA County that has been drawn, with those explanations discussing the bases used for drawing the district with specificity about why each major boundary was chosen. That will help us evaluate the current draft against community information that we receive. We plan to evaluate further the MALDEF written submission and some other group submissions and provide further input that we may come up with. I think it would be useful to ask the mappers to provide some graphical illustrations of census data, other census data by geographic area to help illustrate potential community alignments. There's a lot of data like income level, education level, type of housing, and the like that might be readily available to the Commission to help see patterns in the areas that we're considering and would help bolster your considerations. And finally, we've talked about this before. I think it would be useful for LA County for the mappers to provide an outline or chart of specific communities of interest that have been identified in LA County with an attempt to describe the geographic boundaries for each if it's ascertainable. Now, if there were time permitting, and I think people are skeptical of whether there is time for this, I would actually suggest there are multiple different ways of drawing the maps in LA that are all consistent with the community of interest and neighborhood information. I would almost suggest having some proposed in a simple form alternatives for the Commission to look at and consider instead of just being presented with one. Instead of doing this seriatim and coming back with one iteration and then you talk about it some more, is it possible to have a couple different examples in front of the commissioners to look at and consider? I don't know if that's practical or not, but that's one suggestion. Okay, a few more words on Senate districts. We think in drawing Senate districts, the order should be roughly as follows. First, there needs to be consideration of whether in putting two assembly districts together, there might be a geographically compact minority population that constitutes more than 50% in a Senate district. Because if there is, then it's likely to be that would be required under Section 2, particularly if we had already determined that the underlying assembly district was required under Section 2. So there needs to be some assessment of whether that's been done and whether we've gotten it right. Second, then, the assembly districts should be joined where they minimize the fragmentation of the geographic boundaries that you all are aware of. And then third, after that, some consideration should be given to the remaining criteria, which would include the compactness criteria. Okay, so those are my general and specific comments. I think it would be good now if I opened up the floor to a few questions.
Commissioner Mulligan.
Did you mention you were going to talk about Congress? Do you want to go do this first, or?
Yeah.
Okay.
So with respect to drawing congressional districts, we had at least one question about one of the districts, which would lead us to give the following advice, and that is that essentially you want to make an effort to go through the same exercise with respect to congressional districts that you've been going through with respect to assembly districts, and that is trying to draw the districts in a way that reflects the public input that you've been hearing, and putting together neighborhoods, cities, communities that make sense. And you have to be sensitive to areas that are under consideration because they might be a Voting Rights Act area. And if it turns out that it's not a required area, I think you need to pay particular attention to the support for how the district is drawn and what the basis is. Because if you end up with an odd-shaped district and you don't have sufficient support for it, it could lead to legal challenges. So that's a bit general, but that's our view on congressional districts.
Any questions?
Chair.
Commissioner Dye.
Thank you. I know I'm even shorter now, but I'll try to hold my hand up higher. Mr. Brown, thank you for that overview. I'm curious, what are the implications for districts where we've drawn it based on community of interest testimony, and it just happens to have a majority CVAP, minority CVAP? Is there some implication if we officially designate it as a Section 2 district, or it just happens to end up as a majority Latino CVAP district? Because you mentioned several that we actually drew completely based on community of interest testimony.
There are a couple of considerations. First, it's our view that because the Commission is obligated to comply with the Voting Rights Act, it needs to look to see where it may be obligated to draw a district. Second is, even though the Commission believes that it has appropriately drawn the district based on community of interest lines, some people might disagree. If you had concluded that it's probably a required district, then you have two levels of argument that support the map.
Okay, thank you.
Commissioner Malloy.
Button on top. There's a flip switch on top.
Commissioner Anchetta.
Yes. So, thank you again for the overview. Just a related question, building on Commissioner Dye's question. Now, for LA County, we've sort of operated on an assumption, given that we haven't had an RPV analysis, that we're sort of working on a play it safe strategy to make sure that we're also covering our bases with communities of interest, neighborhoods, et cetera, et cetera. But it seems to me that increasingly we're getting more information, both in terms of publications and from what Dr. Barreto sort of preliminarily suggesting, is that the presumption may be that there is polarized voting in a lot of LA County. And should we reconsider, not to say we shouldn't gather all this appropriate testimony, but if there's now a presumption that there is in fact polarized voting, or likely to be found polarized voting, should we be much more attentive to explicit Section 2 district lines versus sort of lining up other bases for our analysis?
I think it's going to be very difficult for any group to bring a successful Section 2 claim in Los Angeles. But we have an open mind about that, and we're going to continue to talk to people and listen to the arguments. I believe that you may very well find racially polarized voting in parts of Los Angeles. I think there are a number of other challenges. I do think also that the Commission needs to continue to be vigilant about avoiding steps that could lead to a Section 2 claim, like over-concentration of a single minority in a particular area. But I think if the commission follows the steps that it's undertaken to follow, it will result in maps that are very defensible. It doesn't mean that someone won't assert a Section 2 claim, but I think they'll be very defensible.
Any other? Oh, Commissioner Malloy.
Mr. Brown, my question is actually related to the timeline. As you know, we're running out of time on our timeline. And so my question is, we've had the statewide submissions for several weeks now, and you mentioned that one of the goals that your firm has is to do some deeper analysis of the submissions from groups, including MALDEF, but others as well, I'd presume. Can you give a sense of, will that analysis be complete by the time we do our next business meeting and line drawing session, which I believe is in Fresno later this week or next week? Next week?
I wouldn't necessarily say complete, but having looked at many of the submissions already, I don't foresee anything that we're doing is going to hold up the commission's process. If that changes, we would let you know immediately. I have reviewed the MALDEF submission and other submissions, and I believe the commission is currently on the right path with the suggestions I've made today. But as with many things, we're going to continue to look more deeply at it.
Commissioner Aguirre.
Yes, Mr. Brown. Yes, good morning. Following up on the question of outreach to MALDEF and other similar groups, CAPIFER, for example, that outreach is that something that you would undertake to outreach to these groups? You mentioned that we needed to outreach to groups that had a legal sophistication. So to me, you would be the most indicated person to outreach to them and then bring information back to us. And then the second question is that given the dispersal, especially of Latinos in LA County, and the fact that when we travel in certain areas of Los Angeles, the concentration of Latinos is very high in not only in one area but in adjacent areas, what would be the value of talking about forming majority and minority districts versus a strictly Section 2 perspective?
First, on the outreach question, I think it is appropriate in some instances to have counsel reach out to counsel for some of the groups, and I've started to do that. With respect to providing information, I think that the commission needs to be sensitive to the fact that the only information that can count is public information that is presented to the commission. So on the few occasions that I have spoken to people, what the message has been is to urge them to come back to the commission and provide additional information. So that's what needs to be done. Okay. Not sure I fully understood your second question, but there are strong limitations that the courts have imposed in evaluating the Voting Rights Act under Section 2. And there are limited circumstances under which a group has a claim that will ultimately prevail. And that's why we have to go through the analysis as we've outlined before we conclude that an area is required under Section 2. And that's probably not a satisfactory answer to your question, so I'm happy to respond to follow-up.
Yeah, well, the reason that I asked that question is because the discussion here in Los Angeles has been that the commission has focused on strictly COI information, Community of Interest information, and that was, of course, your recommendation that we needed that COI input. But the argument is that by focusing most of our interest and attention on COI and then drawing districts based on that and knowing that there are communities that are generally underrepresented not only politically but in public input hearings, just because they're disenfranchised and other related factors, that for that reason, then we've raised COI against the second criteria, which is Voting Rights Act. So in essence, then arguing that we have been inappropriate in focusing on a lesser criteria.
Yes, and that's an important question that people have raised, and I would respond by saying that the Commission hasn't done that. The criteria is the same. The Voting Rights Act is the higher criteria. It must be followed, and so the Commission must take steps to comply with the Voting Rights Act. So that's the starting point. The next level of the analysis is what does that mean, and how does one go about doing that? And the steps that we've outlined, we believe, are the steps that you take to go about doing that. I've heard some arguments about potential Section 2 claims in this area of Los Angeles that's under consideration, but not yet persuaded that there is a viable Section 2 claim in there. In part, I think because of the difficulty of showing racial bloc voting that will matter in an ultimate analysis, in part. Not that it doesn't exist, but showing it in a way that it will matter. In part because of the electoral success of both African Americans and Latinos in electing candidates that they prefer. And in part because of the challenge in showing that under the totality of the circumstances, Latinos have less opportunity for electoral success under the maps as drawn than they would otherwise have. I think on the current record, there's not a viable Section 2 claim. It may be that we haven't fully considered some arguments, and I have a very open mind on this, and I'm very interested in hearing from groups that have, or anybody that has a different theory of why the analysis I just outlined is incorrect. But that's where we are right now. That means that you cannot or should not draw the districts because of a belief that you're doing it under the second criteria, the Voting Rights Act, because if it turns out that the Commission is not correct about that, then the maps are vulnerable to challenges that you haven't followed the other criteria or 14th Amendment challenge.
Thank you.
In following up on this point, because I had this same question, and that's what I want this Commission to also understand, is that your last point, that if we looked at an area of Los Angeles that it appears to have geographic compact minority group, but if in the totality of the circumstances, it's in your analysis of Los Angeles County that there aren't any Section 2 designated districts, we have to be extremely careful in making sure we're not setting ourselves up for a potential 14th Amendment claim by simply drawing a district that would be majority-minority, not categorized as a Section 2, if we do not have supporting community of interest testimony, correct?
Yes.
Okay. Commissioner Anchetta was next.
2 points. One, I did want to address Commissioner Galamos-Malloy's earlier query. As you know, Commissioner DiGiulio and I are sort of the work plan implementers, for lack of a better term. We've been using another one, which I won't mention here. Not dictator, of course, but that's something reflecting more power. But in any case, the point being, we did schedule a meeting with Q2 and one of the Gibson Dunn Associates tomorrow to sort of go through the MALDEF maps and do some analysis there and look at some of the other statewide maps. And also, and again, this is based on a conversation that Mr. Brown and I had with Dr. Beretta this morning, just to get a sense of the timelines, which are actually very encouraging in terms of his ability. And I'll bring this up later. It's very encouraging in terms of his ability actually to turn things around fairly quickly, which is good. But he's going to take a look at some of those statewide submissions as well to kind of get a sense of the data and how they might align with how he's going to look at the voting patterns in various districts. So I think that's encouraging. I did want to just raise one question just to see if it's, I think it's a closed issue at this point, but in looking at the Orange County area, I think it's been pretty much your determination that the Santa Ana Anaheim linkage is not one where you feel there's a potential Section 2 claim. Is that correct?
Our analysis of it was that there's not a geographically compact single minority community there because of the fact that the city of Orange seems to run right through where the two populations would be.
Okay. And I only asked the question because I did forward some case law to you regarding at least Supreme Court analyses of compactness and some lower court opinions. But so it's still your determination that that's not really, they're not close enough in terms of geographic area to be compact under the Jingles requirement.
Thank you for sending that Supreme Court case. I thought you were sending it because of the issue in Imperial and Coachella Valley.
I did. It is relevant, though, because obviously that's really far apart.
Yeah, and as a result of reading that, our view is that it's not compact.
Yeah, and again, I think
that's been our view, our leanings, and that case helped further solidify our leanings there.
Yeah, and I think that's an easier case because that's many miles. If you recall, we're talking about the Coachella Valley and Imperial County. That's much more than 5 or 6 miles, which is sort of how the Santa Ana Anaheim gap is. Anyway, but to the extent that the case law is not that clear, except at the extreme areas. Again, I think the case law makes pretty clear that Coachella and Imperial are not going to be a Section 2 district. But I guess to the extent that there was any additional guidance in looking at some of the cases, you still feel that it's pretty much not compact enough at that distance in Orange County.
It's more of a common sense test when you look at the map. At least our views. And I suppose if someone wanted to try to build an argument, you'd want to look more closely at what the community of interest testimony was in that area.
Okay. I have Commissioner Ward. Okay. Commissioner Barava.
Testing. Okay. I'm still somewhat troubled by the use of CVAP and the amount of error associated with that number, particularly when we're talking about really minor differences which would indicate retrogression. Is there any appreciation on Justice Department of that using those numbers as precisely as it's been implied?
You may be talking about two different issues, so let me make sure I'm clear on which issue you're talking about. Are you speaking about the Section 5 issue?
Yes.
Okay. I don't think you have to base your Section 5 decisions on CVAP. Our same analysis applies when you look at voting age population as the benchmark. And the suggestion was, with respect to the small populations, it's unlikely that the DOJ could successfully litigate a claim. So, but we think the better practice would be to see if you can make it completely not retrogressive, because then there are no questions about what was done. And if you can't, then simply provide a narrative explanation for what was tried and why it wasn't feasible.
So if we found a case where you make it no retrogression, but the district really looks funny, or it doesn't tie into the communities of interest, but as to another district, we would be in a position to make that point of view?
I think so, where the population is very small.
Okay, thank you.
Commissioner Blanco.
Oh, sorry. That's okay. I forgot that. We're going to be cozy. So I have a couple of questions. One, when Commissioner Anchetta asked about the short of a legal Section 2 district from the point of view of a district that's compact and has polarized voting, that short of that, what we look at, that we have to be very careful that we're basing it on community of interest in order to avoid a 14th Amendment.
To say it better, it would be other districts.
Right. And the only clarification I want to make there, because in your response to his question, he mentioned, so we'd have to use testimony. And I know I keep coming back to this issue that was alluded to a little bit by Commissioner Aguirre, which is we may not always have testimony, like oral testimony or even public comments, but there may be information about, communities that have similarities and share, have a tradition and et cetera, that we really haven't heard from. And sometimes I think when we look at the Latino population, not even VAP, just when we look at, the demographics, what that kind of tells you sometimes in shorthand is there's a community here that has settled here, that if they have that common ethnic culture, probably has some things in common. But we may not hear anything about that. So I'm a little concerned about narrowing ourselves down to testimony, both oral and written, and that otherwise we're free to just draw maps that don't take into account what may in reality represent communities. So
yes, I think perhaps when
question.
people use the word testimony, they don't mean to limit it that way, but if so, it shouldn't be limited that way. I think the Commission is free to look at objective evidence about where communities are, and I know there are reports and data and publications and census data and demographics. There's all sorts of information that the Commission can take into account in trying to figure out what goes with what, which communities seem to be grouped together, and the like. And I think you're free to collect some of that information and think about it and consider the public testimony, and then try to do your best to do what's fair, being sensitive to not over-concentrating minority populations and sensitive to the interests of minority representation.
So that was my first question. Then going back to the Santa Ana question posed by Commissioner Anchetta, one of the things that about congressional, the congressional boundaries that I know that you alluded to this, but I'd like to know more about it. When you take that Santa Ana congressional area, and in your view, it's not a Section 2 congressional area because maybe Santa Ana and Anaheim are not compact enough.
It was the Assembly District.
It was the Assembly.
Yes.
Okay, so my question is really about Congress, which is, because we'll be looking at that area again for Congress. And what happens with that compactness in a congressional analysis for a Section 2 claim? Would we look at Anaheim and Santa Ana together for a larger congressional district? What is the measure of compactness when you're dealing with a larger geographic or a larger population that you have to build a congressional district with?
I think it's a good question. Obviously, when you have a larger population for the larger districts, the Senate district and the congressional districts, you're drawing over a larger area. And we should ask the question, is there a single minority population that can be drawn, that constitutes more than 50% in this area? And if there is, we ought to look at it and ask the compactness question again. And, I'd want to see it and think about it. Where the different communities are geographically compact but distinct, I'm not sure it meets that first jingles condition. It may be that you choose to draw the district because you believe that it's appropriate to keep those communities in one congressional district, and it seemed to me that you could have reasons to do that. But it may be that if they're geographically separate, that it's not. There's a risk that it won't meet that first jingles precondition.
I'm pondering that with my own question, but Commissioner Dye was next.
Yeah, actually, I had a very similar question, except it was about Senate, and it was back to your comment that when we look at pairing assembly districts to nest them for the Senate, that we should be, obviously look carefully at assembly districts that we decided were Section 2. If we paired, theoretically, if we paired two assembly districts that were Section 2 for the same minority group, we should get a Senate district that's also Section 2.
Right.
But in some cases, there's not going to be a obvious partner. So I guess, again, the question becomes, it's a similar question, how do you look at compactness with this, larger area? Because you were kind of saying it was a common sense test, and when we looked at it together, we were looking at, gradations of red. Mm-hmm. I can tell you I have a lot of students who are PowerPoint experts who could change the scale on that so that it would look compact. Mm-hmm. So, I'm wondering if there's a little more that we can hang our hat on, because we actually, for example, did get a lot of testimony about putting Santa Ana and Anaheim together, regardless of whether it looks compact or not. We did get a lot of community testimony about that. So how do we reconcile that?
Well, I think that you, on the Senate district question, I think that the analysis is, as we outlined, the first question, does it look like it might be a required Section 2 district? And it's possible that you have two majority assembly districts that don't meet the first jingles precondition in a Senate district because they're not compact, because they're only joined at the edge or something. If you're in that situation, then you move the next criteria would be minimizing the fragmentation of those various geographic boundaries, and that has to be considered. And then when you're in that criteria, you're free to choose to group communities together that seem to belong together based on what you know about those areas. So I think you could, if there was a lot of testimony about grouping Santa Ana and Anaheim together, and it fit within a district, Senate or congressional district, you could do it for those reasons. Someone might ask, have you fragmented too many areas? But that's a different question you can evaluate.
So just to make sure I understand, so in the case of Santa Ana and Anaheim, I think we decided because of population, it would be hard to make a single assembly district anyway, regardless of the compactness issue. But with the congressional and with Senate, there's room to put, both cities in, mm-hmm. As well as the city of Orange in the middle. So what you're saying is if we decide they're distinct communities, but they're similar, so it would make sense to group them together. And that's also what the testimony was.
I guess and another way of saying it is that when we say it's not required under Section 2, it doesn't mean the Commission can't draw a district in that area. It just has to make sure it's following its normal practices and other criteria.
Okay, thank you.
Pardon me. Okay. Does anyone else have any questions? I want to follow up on this point just a little bit further, because we do have nestings way down at the bottom, but it is identified in one of our categories. But you had mentioned earlier that we should consider if we're looking at an assembly district that's Section 2, and if we agree with your recommendations that there may only be 6, those are so independent. There isn't necessarily any adjacent population for I guess my question is could there be an argument that if we've been asking Q2 to blend sometimes instead of doing nesting, and if we do that in certain areas because it's supported by the community of interest testimony, my concern is do you see that there's potential risk of an argument that if we have a Section 2 assembly district, that when we either consider nesting or blending, if we do it in a way that might dilute that district on a Senate level, could we be getting ourselves in trouble by making that decision between nesting or blending? In other words, in one area we might have blended for community of interest. In another area that's nearest Section 2, we don't necessarily have testimony that would tie that Section 2 assembly to any necessary other assembly district in the area, so we might just nest the two together based on the criteria. But could there be an argument, well, you blended over here. Why didn't you blend over near the Section 2 to create potentially a greater percentage of a minority group in the Senate district? So now what you've done by nesting, you've diluted our vote that we had, the strength of our vote at the Senate level now, instead of looking at it broader.
I think the requirements for a successful Section 2 claim are so narrow that if you don't get past that first criteria of having a 50% majority in the proposed Senate district or an alternatively drawn Senate district, then you're not talking about Section 2 anymore for the most part, unless there's an argument that something was done purposefully. So I think that's just the threshold issue. And even though there are good policy reasons for making one choice over another, it's not a Section 2 issue. So then the commissioners are going to then have to debate what the preferred approach is, assuming there are alternatives that are all consistent with the criteria.
Okay. I had one other question when you were discussing recommendations that this commission should consider in instructing Q2. It was under the Section 2, and you had suggested that we ask Q2 to do further evaluation of CVAP in San Gabriel Valley and more likely in Santa Ana and San Diego. And you had made a comment to potentially instruct Q2 to look at adjacent population to those areas in order to push the population over 50%. Is there a maximum? I mean, if we don't give some better instructions just to say over 50%, we want to find that line between, we don't want to highly concentrate if we're looking. So what should our specific instructions be? I mean, go out, look for adjacent population, but where should the percentage be?
Yeah. The way I envision things is you ask a question, you get some information back, and then you get further instruction. It's not as if we can automatically pre-program what's going to happen. So the first question is there an adjacent population that, if added, would constitute at least 50% CVAP in a geographically compact area? That's the first question. Now, if you get to a point where you decide that a Section 2 area is required, the next question is, how big should it be in order to be effective? And that's where it's going to depend on the facts of that particular area.
Because you could get in a situation where you don't have a geographic compact if you're flowing out from,
Threshold
let's say,
question
the
is there something adjacent? I'm assuming that if there were an adjacent population that pushed over 50%, they would have flagged it for us already, but I think it's worth asking.
Okay, any other questions? Oh, apologize. Commissioner Yao?
Let me use the Stockton finger as a situation for discussion and not so much about the Stockton map per se. If we have an option to go back to implementing the Stockton finger, and by doing so we can raise all these statistics on the minority group, what is the justification that we have in terms of not implementing that option? Here's my thought. If we look at Prop 11, the priority, the Voting Rights Act is the second highest. way above the community of interest, city, and all the other factors. And the Voting Rights Act suggests that we need to preserve the minority.
Yes.
So when you gave us the option of not or going to the other option without using the Stockton finger because of the compactness, because of all the other criteria, I need to understand as to on what basis are you giving us that advice when,
right?
In the way I see it is we are not really given many options to begin with.
It is an excellent question. The basis for not drawing the Stockton finger or any similar situation is that you reach a conclusion that Section 5 does not require you to do it because it's not retrogressive to the community when you look at the totality of the circumstances. That's really where that's really what we're saying at the end of the day in the advice we've given on this. And it would not be retrogressive under the totality of the circumstances if, in fact, the Hmong community that's reportedly in Stockton is distinct from and not politically cohesive with Asian populations that are in Merced. If that's the case, then there was not effective political power with that 11% to begin with, and therefore eliminating the Stockton finger didn't change the situation. That's really the argument. It's under the totality of the circumstances. You haven't actually gone backwards on the effective participation in the political process for that group. Now, let's go to the other extreme. Let's assume that the 11% Asian population, together with Latinos, are politically cohesive and vote similarly and have had effective participation together in elections. But now I think you'd have reason to be concerned about then reducing the population to the 6% from the 11%. And then your question also suggests another thing that ought to be considered, and that is a question. I think it has been asked, but a question should be asked. Is there another way to maintain the 11%? And I don't know that there is, but it's at least worth asking.
Thank you.
Commissioner Malloy.
Mr. Brown, one of your recommendations for us to take into consideration with our mappers was to request that they put together some sort of summary list regarding established communities of interest in the Los Angeles area, along with the geographic boundaries that they would roughly correspond to. My question is how we think about doing that for the rest of the state, or your assessment on whether, in fact, we need to do that for the rest of the state. I know that we have had some conversation about tracking designated COIs. As a commission, I believe we had tasked if I'm remembering correctly, the technical and legal team to think about this a little bit. So clearly LA is a more complex region, more densely populated, but is by recommending we do this in LA, are you inferring that you would not think we'd need to have that same standard of documentation for the rest of the state?
Let me explain what I think some of the issues are, because I think at the end of the day, what you need to do is make judgments informed by time limitations and resource limitations. At the end of the day, when if the maps are challenged, perchance, and a particular region is focused on, and the challenge is that there was an incorrect basis for drawing the district somewhere, the commission is going to need to have evidence somewhere of what supported that conclusion. And so in the area of Los Angeles, I'm asking that we undertake now to try to develop what we think the evidence is, because it'll help us evaluate whether the commission is comfortable with where it ends up. In other areas, you may be, if there are not lots of potential disputes in the area, and the commissioners broadly agree that they heard all the similar testimony, you could take a little more comfort in making that a lower priority in developing, exactly what community of interest did we decide in this area. So it's really a judgment call. In areas that are more, robustly debated, I think you want to be a little more vigorous about developing the record.
Commissioner Dye.
Yeah, Mr. Brown, this is a follow-up on Commissioner Yau's question about the Stockton finger. So I actually looked back at the 1991 maps and saw that the finger wasn't there. So this is just a hunch.
You mean the special masters didn't include it?
That's right. This is just a hunch, but I would posit that maybe the Stockton finger was put there not to boost API voting power, but in fact to boost Democratic voting power. And I suspect that could be supported, if needed, by numbers. But I guess my question, because I don't know if we even need to go there, but my question is, given that, incumbent protection was a, standard redistricting principle back in 2000, but it is not this year, could that be part of our justification?
Well, yes. I think it would go into the discussion of the totality of the circumstances.
Great, thank you.
Commissioner Anchetta.
Yeah, that was a point I was going to bring up. The other dimension, which I think, and Mr. Brown can elaborate further, but one of the issues, of course, is when the minority populations are small, and given revisions in Section 5 after 2006, where the focus is now on the ability to elect, and basically ability to elect means sort of the 50% mark. You don't necessarily, well, you have to look at the numbers, obviously, but to the extent that there may be coalitions building, that might affect your analysis. But when the numbers are smaller, and this is a question, is 11% too small? 5% probably too small to really sort of say you have an ability to elect. But as you get a little bit closer to 50%, then you start thinking, well, maybe there's something there, right? So that's an issue. And I think at some point we have to make a call and just sort of say, well, given that, as Commissioner Dye mentioned, and it's pretty clear in the 2000 maps and the 2001 maps and the 2001 Section 5 submissions that they weren't thinking about Asians, right? I mean, they weren't. I mean, that's not in the submission. They're looking at Latinos. And no doubt, I think our assumption is probably correct that it was a political, a partisan gerrymander. That's probably right. I think we have less to worry about, but again, it's just sort of thinking about, well, it's up there, right? And is it something we really have to think about? And I don't think there's a really clear answer regarding whether 11% is at that sort of threshold, but it's clear that because the law was changed in response to a Supreme Court decision that actually said you could sort of go below 50% to create influence districts, that the new statute or the new version of the statute really looks at the 50% mark as something you really should be more attentive to rather than sort of smaller variations of percentages. But again, it's one of those calls where you kind of go, well, that's a significant number. Should we take a look at it or not?
I don't quite agree with your interpretation of where the law is, and I want to explain that. But first, let me say that I think directionally, if you follow the steps that we suggest, your decisions about the district in the Merced area should be very defensible. The reason I don't disagree is because I don't think there's been a case law interpreting what's happened between 2003 and today. And what happened was in Georgia versus Ashcroft in 2003, the U.S. Supreme Court evaluated a disagreement about whether one should be maximizing majority districts in protecting groups under Section 5 or whether other approaches like drawing influence districts should be considered in evaluating retrogression. And the Supreme Court said that it's a totality of the circumstances test. Now, Congress reacted strongly and amended the statute and may have created some unintended consequences. So Congress amended the statute because they wanted to make clear that where there is a pre-existing majority, it needs to be protected. And that means where there is a pre-existing ability to elect, meaning over 50%, it needs to be protected. Now, if there was an interpretation that says that's all that matters, that would mean that Congress intended to narrow the scope of Section 5. I don't think anyone has suggested, I haven't seen anything written that suggests that Congress intended to narrow Section 5 when they amended the statute in 2006. And it remains to be seen how that will come out. So in the meanwhile, our view is that there's still a totality of the circumstances test, particularly when you're dealing with populations less than 50%.
Yeah, and I'm not differing with that basic opinion. And of course, Commissioner Yahoo wants to have precision and unambiguous law. This is one of those areas where there is ambiguous law because we don't have a court case saying exactly what the law is, which is why lawyers might disagree over these matters. But anyway, on advice of counsel, we should rely on advice of counsel. Right?
But I do encourage any of you who hear legal arguments or have ideas, we want to hear them because that's how you get to the best and most appropriate result.
One of the purposes of having Mr. Brown here is that we do have on the agenda today to make some decisions about Section 5, so I don't want anybody to come away not feeling as if they've had all of their questions answered. Mr. Brown, I'm in looking at the worksheet that you had prepared for us, and I encourage all the commission members to, if they have any questions regarding this, we'll probably taking a look at it when we have the discussion on Section 5 later today in the agenda. So if you have any questions for Mr. Brown. I have a question on here in your spreadsheet, excuse me. You have on here, for instance, for Merced and I think in a couple of the other areas, to confirm the understanding of the term Asian American as used in the Voting Rights Act. Can you tell me what your thoughts were on that statement?
Yes. We all know, because we live in California, that there are many different subgroups that people casually refer to as Asian. And the Federal Voting Rights Act doesn't make clear what it meant when it used the term Asian American. So I wanted to make sure that we have an understanding of what the mappers are using when they're accumulating groups under the designation Asian so that we're being consistent. I want to make sure we understand what groups they're including and that they're being consistent.
Being consistent throughout the use of the term
Yes.
and how we use them through all the Section 5.
And Section 2.
And Section 2. The other question that I have is if you could please advise this commission regarding your opinion on the 2 Board of Equalization districts that are covered by Section 5 and what your opinion is in that regard.
Yes. As I recall, the northern 2 draft BOE districts cover Section 5 counties. One of them was not retrogressive at all, and the other one had a similar issue as with some of the other areas we've looked at, in that there are small changes that are going short of the benchmark for each of the groups. And the question really for the mappers is, why can't, there's only 4 districts. Can you make the maps so that they're not retrogressive at all? And again, it's not that you couldn't defend a slight change. It's just, why not make it really easy by having them fully meet the benchmark?
The one other question that I had is you had mentioned, as I had stated earlier, the Commission desires to make some decisions regarding Section 5. What do you anticipate Mr. Barreto might be able to assist you with in aiding this Commission on Section 5 decisions that we might make?
I had a chance to speak with him this morning and talked about a number of issues, and we talked about this area. And I asked him to think about how we might evaluate whether there's any political cohesiveness between people categorized as Asian in Merced and the group that's in Stockton.
Do you feel that there's any information that he will provide to you that may impact your recommendations as you've made to this Commission thus far that may, limit our ability to make some decisions today? Do you anticipate anything that might be significant?
What we've tried to do generally is, using our judgment, try to anticipate where things are headed in forming our advice. And so if something comes to our attention that would change the direction where things seem to be headed, we'll let you know right away.
Thank you. Commissioner Baraba?
Yes, it occurred to me, if we're looking at the definition of Asian, we might want to make sure that the numbers that were used in 2000 are the same ones that we're comparing against in 2010.
Commissioner Anchetta?
And I think that the specific question, and we can simply, this is a question you have to ask Q2, what they're using, but the Voting Rights Act uses the term Asian American, and since 2000 at least, there's been a break between, it used to be Asian Pacific Islander was a single number. Since 2000, it is Asian American as one category, and then Pacific Islander as a separate category. And I think we'll have to check with Q2. I think Q2 is just using Asian only. But I don't know that for sure. But I think we casually just use API because we're used to using API as a shorthand for those two groups. But officially, they are separate groups under the census data. And the statute, I think, would not include, but that needs to be confirmed as well, that Pacific Islanders are not within the coverage of the Act, strictly speaking. But we need just to get Q2's answer to that.
Could that be problematic if Pacific Islanders are not covered under Voting Rights Act, but is that what you're saying? And yet they're being included in the API number that if we get this information from Q2, that's forming whether we're reaching the benchmark on Section 5 and not retrogressing. Are we really talking about the same group? Is that what your concern is?
At this point, I'd like to move one step and get more information. Commissioner Anchetta may know more about this, but the question in my mind is, what did Congress mean when it used the term Asian American in 1982? And if they didn't say anything about it in the legislative history, then it's a question for us about what do we think should be included. So I want to start by understanding what the mappers are doing. I'd like to get Commissioner Anchetta's views if he has some information about this. But that's to me, the starting point would be, what did Congress mean in 1982 when they used that phrase? And if they didn't mean anything in particular, then we have to make some judgments.
Commissioner Blanco?
So this is both a work plan and a legal question. So in terms of the work plan, in the work plan that you provided us, and you mentioned it earlier today about in Santa Ana looking at adjacent population to see if there is a compact over 50% CVAP for Latinos, because then it could potentially be a Section 2, and then we'd have to do the RPV analysis. So that would be the sequence. We almost have to have first a response from Q2 about whether there is the potential of an over 50%, and then we need to get that to...
Well, we don't have to go seriatim. I could ask the question of our analyst, see if he can add it to his list.
Right, because that way we can, because I'm just worried that if we do that, and that we go through Q2, then we go to the analyst, and then we're way down the road. I'm a little... The other question I have concerns this whole area of our map, both in assembly and congressional. One of the, I think, I'm not positive about this at all, but I think one of the reasons that area of the map is complicated is because we have very, very clearly defined community of interest testimony from Asian communities that testified in that area, the Westminster, that whole sort of, I don't know if it's a corridor, it's more like a nucleus of various Asian communities in that area west of Santa Ana. And so we were very mindful of that in our maps. And I'm wondering what legally, given our criteria, if we did that and in doing that we potentially didn't draw in something that could have made over 50% Latino CVAP, aren't we at risk of having not gone in order of the criteria?
Yes. So that's why you asked the question, is there an adjacent population? Because if you're over 50%, then that could take priority.
Commissioner.
Could I just have a logistical note, just for the sake of kind of keeping discussions that are going to occur later on going? I think, I think Mr. Brown is okay with this. That if we refer to what Gibson Dunn put together as a task list, and that the work plan that will be coming from the commission will be something different, just to try and keep our work plans separate, if that's okay. Thank you.
Any other questions from? Oh, Commissioner Geary. Apologize, I missed you.
Yes, I had a question about retrogression. In a couple of the Section 5 counties, we have retrogression not only in the Latino CVAP, but in the Asian and Black CVAP. So how much, what would be your opinion in addressing all retrogression for all three groups, or should we primarily look at the Latino CVAP, being that that's a primary minority group in that area?
Yeah, our view is that it would be that you have to look at all groups, and that the preference is to see if you can make all of the groups equal or exceed the benchmark. If you can't, with the small populations, give a narrative explanation for why, what was tried and why it's not feasible. And I think for the smaller populations, percentage-wise, it's unlikely that the DOJ could bring a successful claim. What I want to help the Commission avoid is any ability to be challenged on the Section 5 areas, even if it's a reason that ultimately wouldn't prevail. In at least one of the Supreme Court decisions, the Supreme Court has said that if you meet or exceed the benchmark, that's the end of the inquiry. There's no Section 5 violation. So you make it easy for yourself if you can get all the way there, even though there are lots of arguments about why you don't actually have to.
Sure. Thank you.
Any other questions of Mr. Brown? Commissioner Dye.
Yeah, I'm curious. I mean, we spent a lot of time comparing numbers, which, obviously we can do without, the legal power that you have. I'm curious if there's any history of the DOJ bringing suit for these smaller populations.
I'm not aware of any. There is some case law that suggests that the smaller populations wouldn't have an effective claim.
Any other questions of Mr. Brown? Seeing none, anything that you would further like to add in summary of your statements today, Mr. Brown?
Only that we likely have numerous specific comments on various districts, and at some point we should find a way for us to communicate those to you.
We did receive a list. What were your thoughts on how the commission should address that? Because we are going to get into developing a commission work plan later on today, and it's in our agenda. How do you see your recommendations and your thoughts in that regard playing into what we need to accomplish?
I think it'd be useful if the commission worked into its schedule specific times for us to talk about the specific district-by-district comments that we might have, including the list we sent around. And if not on the same day, a specific discussion about the Senate districts. Once an area of assembly districts is settled, it might be useful then to address the Senate districts to see specific comments and choices that were made.
Do you feel it's beneficial that you would run through assembly districts first? Let's say, for instance, if we invited you back at our next business meeting, which is next week in Fresno, and you were to focus on the assembly districts, then this commission could actually make decisions with its line drawers next Thursday, come to some conclusions regarding those assembly districts, and then have you come back and look at the decisions that we made as to assembly, so then you could render an opinion to us regarding Senate. Is it taking it?
that order makes sense.
Okay, I know I might be infringing a little bit on maybe Commissioner DiTullio's idea of a work plan, but just if that hadn't come up, that might be workable, to put it in that type of structure, if that would be.
Yeah, we'd have to work out the specific dates.
Sure. Okay. Commissioner DiGiulio.
And to speak to that, I apologize. I can't quite do this at the same time, so excuse me. Or not very well. I think that one of the things that Commissioner Anchetta and I have been recognizing, as we all have, is a limited time that we have, but the need to be able to really get through some of this analysis. So we really do see some dual tracks going on here, and that it's not. I think we all probably recognize there's some significant changes that need to be addressed in areas on our maps. And so the idea that we'll be proposing is some of this is going to take place as we go along, so that when we get to the line drawing, we're not all of a sudden chugging through some of these issues, that we're going to try, as we've already done, identified some of the areas. And in an effort to try and maximize all of our consultants' time, too, is our idea is, instead of having so much comment by Gibbs and Dunn on these maps, first maps, is I think there's going to be a recognition that we're going to change them, and as we're changing them in this process, that we will have the involvement of Gibbs and Dunn, so they can kind of, for lack of a better word, make some recommendations in real time as we're going through this, so that, and then also once we've made, we can't only go so far until we actually do the physical line drawing. I think we can get good progress on these issues prior to our line drawing sessions, but hopefully we will have been able to vet through at least enough issues that it'll keep us on track. And then once we get to the line drawing sessions, we will hopefully have worked through those big problems, and then again, Gibbs and Dunn can continue. We will have built in time during our line drawing sessions so that they can review what we've done. And part of that is an extension of some of our line drawing sessions to accommodate the need for us to get it right and for enough review by our legal team, if that kind of gives you an overview. And I don't know if Commissioner Anchetta would like to build upon that as well.
Yeah. Thank you. I mean, one thing and we're going to pose this in our discussion, because we are going to propose some sort of parallel tracking, so there's some ongoing analysis, starting really today, of the section. No doubt the Section 5 districts are really close to being what they will be, but for the Section 2 districts, we want to really get a head start, and we're going to pose a couple of questions regarding how much delegation of responsibility and how much you actually would want to see done going into the first line drawing meetings. And that's a significant question in terms of who does what and how much do you want to do. If you want to really do a lot of work preliminary, a lot can be done, but it means delegating significant responsibilities. If it's really something that the Commission as a whole really wants to dig in at the first line drawing session, that's another way to look at it. But you'll get less done ahead of time. In either case, I think we have to make sure on this round that VRA Council is there in the room with us. And so it's not sort of the back and forth and increasing the number of steps in between our instructions and Q2's working on the maps, and then they're coming back, that at least things are moving all together at the same time.
And can I just say, if that wasn't a little bit of a hint by Commissioner Anchetta, we will be coming to you about increasing your involvement on some of these responsibilities. So have that in your back of your mind about how you'd love to step up in the future.
Any further questions of Mr. Brown? Thank you very much,
Okay,
Mr. Brown.
thanks.
Appreciate it.
See you soon.
Okay. At this time, we'll take a 5-minute break.